everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button for me. I appreciate all the support. There's a PayPal link down there for anybody that wants to share some love. Every little bit is appreciated. And the StreamYard link is there for anybody that wants to join the panel. We're going to be talking about enforcement of surety bonds tonight, so hopefully we can go as long as you want to go. We'll put it that way. I got a lot of material here, and do what you will with it. Greetings, John. How you doing tonight?
Doing good, my friend. Doing real good.
Good, good. And if I remember correctly, I think it was you or another guy that sent me this, enforcement of surety bonds. There's two videos, parts 1 and part 2. And so we're going to go over those tonight.
Oh, really? Okay. Yeah, I think I did that, Keith.
Yep. It was, yeah, a couple days ago. Yep. So we're going to go ahead and go over those. I found it to be a very interesting couple of videos, because that's what we're talking about, is enforcement of these bonds and stuff, no matter what kind they are. And lately we've been going over the indemnification bond, which is kind of an equal consideration with that surety bond. We're going to place our own indemnification bond, but we're going to up the ante. Like I said before, they got 75 million. I'm going to call you and raise you 75 million. And we do all this in good faith, under the full faith and credit of the United States, with our comprehension of how those terms and conditions of the contract work. And they've actually already got a contract in play. This is public service, is a public trust. And that's why it's got to be bonded. So if we want to be recognized in that public trust as the obligee, we have an obligor number. That's what was assigned, was a social security number, and its conversion for a different capacity, which is the obligor. That's the obligated party. Again, it's the record. The individual's name and number identify the record. So they're holding the obligor record, and I can get a portion of a bond in form of stock bond of sorts that has that information on there that relates to that record they're holding. And as the benefactor, deemed to be the true owner, I get to control and direct the settlement. And that's the comprehension we're seeking, is just the language of those terms. So again, I appreciate sending those videos. I have not looked at them. I have not watched them. So I'm watching these for the first time right along with you guys. But like I said, it was interesting because it's going right along with what we're looking at. So we're going to see how they do enforcement on surety bonds, so we can do the enforcement on the indemnification through the equal consideration. And I'm sure in their bonds, it's a matter of that placement. Like I said, it's either done through some kind of trade. Is it an initial public offering, or is it a private placement, or is it something else? And that's, I did some research, stemming from enforcement of surety bonds, and found out about that index. Remember that thing with all of the 94 cases has a thing at the top, and it says literally financial index. Well, that index has to be funded some way. That's an index funding. Find out that it's the court registry investment system, and they're mimicking the NASDAQ and S&P 500. That sounds like insider trading to me, with undisclosed conversions.
Yeah, or it's under the table.
Right. It's those blue sky security laws that aren't the same as the national SEC. So they get to securitize them through their pooling of investments. In that pooling, they can't bond it in everybody's individual name. So what they do is they pool it, transfer it, call it their asset, name it in their name, and then that's where they come in with this interest part and a credit default swap. It's interesting. So anyway, let's check out this enforcement of surety bonds. And the links are down in the details section. And this comes from, let me get the name of the site again, Probate Nation. Probate Nation. They've got 423 subs. So kind of a small channel. This video was put out a year ago. So go over and check them out. And like I said, I haven't watched this yet, but we're going to watch it together, and stop me if you want, John. I'll be doing plenty myself, I'm sure.
Yep. Got it.
Like I've said many times, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your own research so you know. And if you're going to go to an attorney, that's the only thing you hire them for, is to further the research. You don't hire them to make a representation. You can hire them to do some further research so you can correlate the information as objectively as possible, so you can put it forth as an objective truth and not subjected to your own perception. You've got other perceptions out there, use them. Not for representation, but for your own discernment.
Welcome to the Probate Nation. My name is Richard Ruddy. As we have learned over the course of many shows, persons appointed as fiduciaries in an estate, testamentary trust, conservatorship, or for the property of a minor child all have to be bonded. In some appointments, the bond might be without surety, essentially a personal bond. In other appointments, however, the bond must have surety, and this means an insurance company must be involved.
And what I found out recently, like I said, I've been dealing with the city council and the mayor here recently. I finally resolved. I got to try to get a hold of him Monday and talk to him. I've been taking time to draw up some questions, and come to find out, it's Iowa Travelers, and the city here doesn't hold a surety bond. They in fact hold a fidelity bond. Now there's a difference in the bonding there, because the surety bond, as we've discussed, is for the performance, making sure that the contract is completed, and then upon completion that the contractors get paid. So it's a performance bond and a payment bond, whereas we also know there's a bid bond. And this is the thing that's missing. There's no true actual bid bond in there, unless you understand the concept that I said before. They're playing a game. It's a big gamble. It's a big bet. And they're coming forth with 75 million, and you're just going to call them and raise them, double it. That's your bid. Okay. So you have to put your bid in. That's all it is. Once you put your bid in, ain't nobody can match the bid, because you double them up. Now they have to perform, and they have to pay their contractors to do so. If anything fails along that line because of a violation against yourself as the benefactor, the very one that's obligated, what you've done is essentially given them permission to use the obligor number to make the proper payments on credit, so long as it's understood that the credit is given to the customer's account. Customer agrees to make third-party payment, so long as it's understood that credit is given to the customer's account. Here, I'm giving you the credit account that it's due from. It's under full faith and credit of the United States. I'm giving you authorization through a directive of the routing to go to the Treasury to get those credits in whatever form you need. But it's to be understood that those credits are given to my account. In other words, there's circulation. This is the Postal Service. This is the difference between the surety bond and the fidelity bond. The Postal Service, if they have a trust set up with them under the narrowcast master trust account, then they have a duty. When somebody gives them a report that something's out of balance, they have a duty to research and resolve that issue within 3 days, so that it does balance, because that's connected directly to the general ledger. So in effect, the surety bond is for the performance and the payment. A fidelity bond is so that it ensures the Postal Service and indemnifies them. It's an indemnification situation for the Postal Service. So we'll go ahead and take a look at that when this video is done. Remind me.
In earlier
So, in
shows,
other
we
words,
discussed the process.
I'll pay you if you pay me first.
Right. And basically, again, like I said, that when you double them up, what you're doing is you're calling their bluff. You're letting them know, I'm the true creditor. You wanna match me? I don't think you can, because it's already set. Your limitations are already set. I don't have limitations.
To apply for a corporate surety bond, when you should apply, and what factors are considered by the insurance company in deciding whether or not to issue a surety bond to insure you. Over the course of our next 2 shows, we're going to examine how surety bonds are enforced against the insurance company providing the surety.
So at the municipal level, this is my curiosity why the city here has a fidelity bond rather than a surety bond. Remember, the resident is a federal, state, or municipal officer or agent, and that would determine that. Again, all these district courts are at the county level. So why aren't they mentioned in there? Because that's the administration, whereas the mayoral form of government is a military form of government, and the administrative courts are corporate branches of that military form of government. At least that's my take on it, my perception.
And
when there is a bond
administration
forfeiture.
means
And
manage estates.
Yes, and that's why they do all that at the county level. See, they try to tell me that the county prosecutor's office tried to tell me they don't manage the probated estates. The fuck you don't. The records are kept in your fucking courthouse.
Then we will examine how the insurance company recovers its losses from the fiduciary. Our show this evening begins by taking a closer look at what is a surety bond and when it is required, reviews of the surety bond application itself, and we will also discuss what an indemnity agreement is. And finally, we'll begin an examination of the types of personal commitments the fiduciary makes when signing the.
So hand in hand, a surety bond goes with an indemnification agreement. So we have a bond that we get from the state. The state's governor and his registrar, the clerk. So it's the commanding officer and the clerk, and they caused a receipt to be issued in which the spoliated owner may use to obtain indemnity. So what he does then is, in contract form, write out an indemnification agreement, indemnifying them. See, that's what the city does with the fidelity bond. They indemnify the post office. This is the indemnification on our side to let them know, hey, dealing with the post office? Yeah, I agree. Where's your narrowcast master trust account? Because it's already an attachment. They're already using it as a residential attachment, a latch onto their military form through the selective service at the local resident level. That's why it's called tenant housing. It's a military term, Lieutenant.
Indemnity agreement in order to get a surety bond. We are pleased to have as our guest tonight 2 attorneys who represent insurance companies issuing surety bonds. They will serve as our guides as we start a discussion on the enforcement of surety bonds. Our first guest is a partner in the national law firm of Watt, Teeter, Hoffer & Fitzgerald in its McLean, Virginia office. Her practice focuses on creditor rights and bankruptcy, including probate surety bonds such as administrator, executor, conservator, and guardian bonds. She is a board member of the Maryland Bankruptcy Bar Association and an active member for the American Bankruptcy Institute, the Northern Virginia Bankruptcy Bar Association, the Walter Chandler Inns of Court, and the International Women's Insolvency and Restructuring Confederation. She has written and presented on various creditor rights, bankruptcy, and surety issues. Our second guest is also a partner with Watt, Teeter, Hoffer & Fitzgerald, located in its Boston office. Her practice focuses on surety, construction, and insurance coverage. Her surety practice has particular emphasis on commercial surety bonds, which includes all.
Very hard R.
She's an active member in the American Bar Association's Tort Trial and Insurance Practice section and is a vice chair of its Fidelity and Surety Law Committee. She has written and presented on various surety issues and is the author of a chapter in the ABA FSLC book entitled Probate Bonds. Please welcome attorneys Marguerite Duvall and Sharcretia DiBartolo. Ladies, thank you for joining us today.
Thank you for having us.
So, Sharcretia, let's begin with the basics and start from the beginning. That is, kind of tell me what is a surety bond?
Thank you, Richard. Well, a surety bond is basically a promise that the surety makes to be liable for the debt, default, or failure of another.
Okay, so who are the parties to a surety bond to this promise?
Well, a surety bond is interesting because it's a three-party agreement. So there is the surety, its principal, which in the probate context is either the administrator or conservator, and then the court. So it's a three-party agreement whereby the surety agrees to guarantee the performance of the principal, the administrator or the conservator.
And see, that's that probated estate. See, they always go to, see, the court is the one that holds that record. And they're saying they're the beneficiary or benefactor that the principal, the other city officials and county officials are obligated to. And that's because that estate is being probated. That's all the voters, all the investors, all the things that, all the things that fund that court registry investment system. That's where the investment occurs. And they're the beneficiary of those investments. That's what's wrong, and that's the bifurcation. That is false. They have swapped positions. That is the imposition. That's the importance of the living will, which is an expression of a living trust. That's all it takes. And I'll be damned if it doesn't say, Our Father, which art in heaven, hallowed be thy name. Thy kingdom come, thy will be done in heaven, or on earth as it is in heaven. That's his will already.
To the third party obligee, which is the court.
Okay. So Marguerite, who are the principals, or I should say fiduciaries, who typically...
Obviously, which are the courts? No, not obviously. Again, if you understand the principle of the trust that it operates in those three people, the courts and the officials already have a contract together to keep that record keeping as far as importing and exporting it. And that happens to the Chamber of Commerce and the Postal Service. Again, those are all officials involved in that public service, which is a public trust. Now there's the third party that is supposedly not interested, when in fact they have a very big interest in it. Again, because if it weren't for the people, there would be no government to begin with.
typically need to obtain a surety bond?
Well, in the context of probate, we see principles along the lines of trustees for trusts appointed under a will, conservators of, say, a minor child or some other similar type of conservatorship.
Appointed under a will. Understand the terms. There's a difference between an assignment and an appointment. Okay, and appointment is an administrator. Assignment is an executor. And these are things done in handwriting as opposed to typeface court orders of presumptions.
Administrators of intestate estates or testate estates, or also known as or executors under a will. So we'll see those sort of principles oftentimes are required to post a surety bond.
So,
okay, again, executor under a will. If it's truly a private will, it has nothing to do with a probate court, period. If it's a private will and they have the authority and power and knowledge to settle their own accounts with their own creditors, making all parties whole, it does not have to be done with a court. That's the violation of the very private contracts of those creditors, making it a public issue.
so just so what is the meaning of a surety bond? Is there some sort of guarantee involved here?
Yes, essentially the way the surety bond works is that by issuing the surety bond, the surety is guaranteeing.
Guaranteeing. That's just, remember, that's just synonymous with grant. They use the term guarantee in the etymology of grant. They use assurance, the same thing. What you're doing is you're assuring that the information is true and warranted. That is the warrant. That's what's happening when you sign these documents and don't do it right. They don't then turn around and sell them because the information is not warranted. It's lacking something. It's insufficient. It's indebted somewhere. It's not wholly true. That's the debt.
The faithful performance of the principal's duties to the estate, the trust, or the conservatorship. Essentially, if the fiduciary doesn't perform those duties.
Duties to the estate. And this is why I say you have to understand how this system works and let them know, hey, that's my estate. You have no power to administrate it. And as long as I have my living will and I understand that concept, your threats to tell me I have to write something down for your silly ass doesn't make a goddamn bit of truth. That just shows that you're still willing to push some false authority. I assure you.
Then the surety will, generally in the form of monetary compensation to the estate, trust, or conservatorship, pay in to those estates for the failure of those duties to be performed.
So are there typically any conditions on the bond?
This is basically it's faithful discharge of the duties. We expect, or say our clients,
Faithful discharge of the duties. That's the discharge. This is the full discharge, and then the acquittance of the remittance. See, they give you a coupon so you can give back to the commanding officer. That's that receipts. If the commanding officer shall cause receipts to be issued, they may serve the spoliated owner to obtain indemnity. How do you obtain indemnity other than by the one that issues them? You give it back to them. It's the same condition with a promissory note. When you put a promissory note out and you fulfill the conditions of that promissory note, the one that's holding that promissory note is supposed to give it back. How come the banks never do that? 90 days out, they turn around and sell it. Because the debt's already been paid. And you never requested your promissory note back at closing. You should have known that the debt was already been paid. Because they went to the federal discount window and used your credits, your drawing rights, to obtain credits 10 times what you were asking for. And then you set that portion you were asking for aside, and then invested the other 9 times in their internal trading system, and then made that money back, and then turn around and loaned you that money to yourself as if though it was their money. Understand how this system works, and let them know, hey, 75 million? Okay. I call your bluff. Here's 150 million. Now do your damn job from here on out, or else I'm taking everything you fucking own.
expect that when they issue the bond, the principals
So
will
if we
basically perform the duties of the
if we
position.
pull the warrant, Keith, they're left hanging with their pants down.
Correct. That's why the indemnification agreement is a private placement, because we're holding the warrant. Now there's no warrant to pull. It's got to come from us, and it's already in its private placement. So anytime they issue a false warrant against us using our property, we adopt it, put it in with our warrant, say, here's the fidelity bond with the Postal Service or whoever's carrying their surety bond. Say, here's the breach. I want everything he owes me. Here's the charge. What's he own? I want it all.
That they're placed in, and that means filing inventories and accounting and properly dealing with assets of the estate, conservatorship, or the trust. And so the conditions are the faithful discharge. And if those conditions aren't met, if our principal hasn't done what they're supposed to do, that's when the bond might get triggered.
So,
So again, understand this. Scott versus McNeil says a court of probate has no jurisdiction over the estate of a person who is in fact alive. So if they have no jurisdiction over a person who is in fact alive, then why do they hold their records? They're all in probate. If they were your records, they'd be private, not in a probate situation in a public record. That is material fact evidence right there in their possession that says they don't know what the fuck they're talking about if they're holding estate property in their records and saying they're not probating estate property without proper authority. My yay is my yay, my nay is my nay.
Sure, Creech, let me turn to you. So is the bond really almost like an insurance policy?
No, Richard, it's not. It's what Marguerite said. It's a guarantee and it's a promise. It does provide.
So there's a distinct difference in insurance and a surety bond. A surety bond is a guarantee. Insurance is not a guarantee.
Some protection to heirs and creditors of the estate because the surety would be in the position of potentially reimbursing the estate if there has been some sort of failure to discharge the duties of the estate by the principal. But it's not an insurance policy, it's a guarantee, and it's only secondarily liable, and it's only liable if the principal is liable to the estate.
So is any loss that the estate incurs covered by the surety bond?
No, it's not. And that's really one of the ways that it does differ from an insurance policy. So the losses that are covered by the bond are only those where the principal fails to perform his or her trust. So the bond is really meant only to cover losses that relate to mismanagement or waste or fraud. There's no liability of either the principal or the surety unless there's been a violation of the principal's duty of care to the heirs of the estate or to creditors or to a ward if you're talking about a conservatorship. So if the estate incurs a loss, but the principal exercised reasonable care in performing its duties towards the estate, then there's no liability either for the principal or the surety.
So there's no liability for the principal or the surety. Whereas when they're all acting out of capacity, then they do hold liability. They lose their immunity once you give them notice. Hey, we need to speak to you about the probated estate. And they try to say, oh no, we don't have anything to do with that. The fuck you don't. You're a gatekeeper to the courthouse as the county attorney and directing everybody under your directive about those records. You, the clerk, and the administrative law judge, Postal Board of Contract Appeals, and the judicial officer. And you're all supposed to be neutral and independent within the Postal Service. So again, the importance of pointing out the difference between a surety bond and a fidelity bond. I think there's a distinct difference because of that. And again, it comes from the mayor. So I have yet to find out who the county's surety or fidelity holder is. They don't want to talk to me about that stuff.
So if an estate though has
So-
no
so
money, does
Keith-
the surety bond?
It's a warranted public estate, the way it
Correct.
was
Correct.
set up, right? And pro means the future. So probate
Correct.
means it could be settled in the future. Okay.
Is the surety bond still liable to estate creditors?
No, it's not. I'm assuming that there has been a faithful performance by the administrator, and that there, has been no issue with how they've handled the property.
Faithful performance by the administrator. He's the one that's supposed to perform under faith. So again, if he's supposed to be performing under faith, how is he the beneficiary? To their benefit, obviously. Remember what she said earlier? So if they're supposed to be benefiting, how is it they have a required performance? Because they're under the public service, which is a public trust. They are not the beneficiary. They benefit through emoluments, I'll agree. But the administrating the estates and making profit off of them through investments, giving orders to the clerk for inside trading, mimicking the national trades of NASDAQ and S&P 500 and various others. And I'll show you that. I'll show you where it says they're mimicking.
There would be no liability for the surety or the principal.
And so this I understand, is there a limit as to the liability of the surety?
Yes, in that way, it is kind of like an insurance policy. So what we call it the penal sum. So the penal sum of the bond is the limit, and that's set at the time that the bond is issued. And the surety.
And this is why a lot of those people tell you to get the penal amounts from the U.S. Code, and then set forth a fee schedule for when they do violate you. That's part of the indemnification, surety, and fidelity and all that. There's got to be an amount there. So in that, they bring 75 million to the table. You double it up to 150 million. But within that amount, you've got to give them a fee schedule of how much it's going to cost for each violation. And remember, we saw the one SEC agreement for 100 billion. I know in the code it says something about 100 million for a birth certificate, and you can get 10 a year. Whatever. Just saying.
Liability is never more than that penal sum.
Okay. Well, Marguerite, let's turn to when are surety bonds required to kind of give a little more detail. And I want to express my appreciation to the Fairfax Probate Office and Jason Pardo, the manager there, for his help in kind of fleshing out some of these details for us as we go through this area. So Marguerite, for an estate, when can a bond be without surety?
So there's a couple instances where for an estate, and when I talk about an estate, I think it's important to talk about in this instance, an estate in general. a bond can be without a surety when the assets are less than $25,000.
Mhm.
So, you see some very small estates out there, and the risk essentially to the beneficiaries is very little. There's just not a lot there, so they're not going to require the extra expense of getting a bond. You'll also, an estate can also be without a bond when the fiduciary or the co-fiduciary is a bank or a trust company. Essentially, there's some, people think banks are good and trust companies are good in the sense that they're going to fulfill their duties if they serve as fiduciaries or co-fiduciaries. And so there's a security in and of itself by nature of being that kind of entity. A bond will also not be required if all the beneficiaries for the estate are also the fiduciaries for the estate. So that means if
Do you understand what she just said there? If the fiduciary is also the beneficiary, again, that's the trustee is also the beneficiary. You can't do that. They are getting paid as a benefit for their job, their performance. If he's going to invest in that estate, he may do so with his own private funding. But to demand that he get it from the very man and then use it as if though he's investing in the fund and not give it back to the man that he's demanding it from through fines, fees, penalties, and stuff that he's not actually subject to because he's not a corporate entity. Understand the difference between a probate estate and a corporate entity. Ain't too much difference. Neither one of them is supposed to exist with a living will. They're all fictions. That's what they don't want to expose. Again, it's very simple, basic math, though. If they're managing the estates and they're holding records that belong to me as the estate records, then obviously they're using my private property in their public investments as a matter of probating an estate through their administrative investments, through the court registry investment system, and using the obligor number to access that estate accounting. Again, it's a matter of understanding your position in that public service as a public trust, being the benefactor that steps in to settle all the accounts, paying off all creditors so that all parties are made whole, and controlling and directing everything from then on.
And who would you say is like the main person scheming on us? Who's trying to get away with it? Who's pulling it off?
The ones that created the system. And it's just working. Yeah, it's working perfectly for them. The military mindset is what I'm going to call it, because I don't know who all is involved, but that's exactly what it is. It's the military mindset of materialistic controls, which is the supply and demand chain, which is very easily accessible because we have so many fucking people that think comfort and convenient is the way to go, instead of acting like true grown men and women that are stewards of this earth and teaching our young ones how to live naturally instead of growing them up to be cupcakes bigger than we are. We pay for our father's sins, yet it doesn't seem like we are because we're growing worse and worse. It's pathetic. But that's the basic element, is they're using that enumeration system and how they can convert the numbers in the background as officials in that military government and say, well, we'll just direct it here. He gave us a signed document. That's all we need. His will. He signed the document. He executed his free will act and deed. Every signature is a deed. You signed it as your free will act and deed. Stop it.
you have 3 daughters and their mother has passed away and they're the only 3 heirs to the estate, and all 3 of the fiduciaries.
See, when I walked out of jail those numbers of years back and refused to sign any of their documentation, and they said, well, we can't let you out unless you do sign. I supported my free will act and deed of not signing by showing one man who had signed his free will act and deed on a document that said they were supposed to let me go. And that if they didn't, they were going to violate his free will act and deed. And I didn't know if they'd like that too much. He might not like it. See, they have authority that they have to bow down to. I don't bow down to none of them.
So you wouldn't sign, and how much more time did he get?
None. They gave
Okay,
me 60
I thought
days.
you had like a. I got
They
you.
gave me 60 days, and in fact, they gave me 13 days good time. I got out in 47, so almost 2 weeks early. Then, when they let me out, they had this document that said release paperwork, and they wanted to sign the release paperwork so I could go on and start signing these other documents of returning my property and stuff. No, I didn't sign any papers coming in. I'm not signing any papers through. I didn't sign any through the court. I'm not signing any on the way out. Well, you have to. We can't let you go unless you do. I pulled out the judge's discharge order. Said, you're going to violate the judge's discharge order? I was out of there quicker than I'd been out in 30 years
Now, why don't you sign?
because they have no authority. I'm the only one that can give them authority to use that numbering system.
Gotcha.
They know how to use it. I don't. Why would I give them same principle with the banks? They know how to do the banking. I don't. Why would I hand my banking over to them?
Yeah, I've heard you and a few others talk about it before. I figured it out, but
Yeah,
I
it's
just
a
I'm just
matter of that having that knowledge, so that if you do have that knowledge, then you can hand it over to somebody else. It's like a babysitter. You grow up and you raise your child up a certain number of years. My mom didn't want to separate from her natural born son for 3 fucking years, 3.5 years. She never had a babysitter, nothing. Anywhere she went, he went, and wherever he was, she was. And finally, by the time she got a babysitter, um, it was because she had an experience of how that child needed to be treated. And she had to discuss this with the babysitter and teach that babysitter her principles of doing for her child. We don't get that anywhere else. We have to learn how to raise our own children naturally, and then we turn around and off it on to somebody else and we have to teach them. We wouldn't just naturally hand our children off to somebody that doesn't know. So where do we forego the thing about teaching our children ourselves? That's the biggest loss in our own family, is we do it ourselves for that comfort and convenience again.
Hey Keith, that whole shit with Florida, no warrants.
Absolutely.
Yeah,
Awesome.
I'm good.
Awesome. And greetings, Iman. How you doing tonight, sister?
All is well, brother. A lot of stuff is registering with me tonight. And I do have some questions, so I'm just going to follow along with you because I'm getting a picture.
Absolutely. I hope so. And guys, again, I know it's this thing about puzzles. Um, if I were to go to the store and look in the children's section for a 100-piece puzzle, I could find a 100-piece puzzle, but the company that makes that puzzle is probably going to have 4, 5, 6, 7, 8 different other puzzles right there in that same section. Other 100-piece puzzles. Now, if I was to buy like 5 or 6 of those puzzles from the same manufacturer with different pictures on them, though they have different pictures, likely the die that they use to cut those puzzle pieces is all going to be the same. So that if I took all those puzzles home and dumped them all out on the floor and mixed them all up together, I could still come out with 5, 6 different puzzles. But it might take a little bit more to find out which puzzle pieces actually go to which puzzle, because I may not find the right picture. It might take me a while to find the right pictures. They'd be full puzzles, but they'd have puzzle pieces from 5 or 6 different puzzles because they all use the same die. So it's an inverted form of confusion in our world to think that all these different jurisdictions are actually the same die, but you get a different picture from them. That's all we're doing, is correlating the different jurisdictions. They're all saying the same thing.
Yeah.
Then a bond may not be required in those circumstances. Likewise, and that's if whether there's a will or there's not a will. And then if the will waives the bond. So oftentimes the wills will say bond is waived. And there are instances where sometimes people request that the bond be waived, and all this is also subject to ultimately court review and approval, and sometimes the court can require a bond even when the will might have waived it because the assets of the estate are such, or another beneficiary has requested it. So there's always exceptions to the rules, but those are generally what a bond is without a surety.
I think he's
Please
got
bear with us.
Yeah, I think he's got those on the higher speeds.
Okay, yeah. So this is where a guy could really put his will to test and put his testicles on that table and testify to his will and just waive that bond himself. I assure you, my word is my bond. What is it you truly seek? Because I know there's something better than that money. Don't you seek something a little bit more truthful that might not burn your ass so much as trying to lay ropes that'll hang you in your lies? It's about correcting that record, and that record is false. It lies. Go ahead, sister.
Question that I have, Keith, and it's just relevant to me. It's making a picture in my head. Someone has a will, right? And it's drafted up a while ago. This is just a scenario. I'm just trying to get answers. And the will is created a while ago, and it seems like everyone that was named in the will, something drastic happened to them in a demise where they ascended before their time, right? So
Okay.
if in a situation is where the one who created the will is the only living man or woman, then does that mean what you're saying? If the will creates, you said something about the will creating the surety or something like that. Did I hear correctly? Just
No, the will can waive the surety.
okay, so it waives the surety. So say for instance, in a scenario, if everyone named in a will ascended through some kind of the demise, or as a decedent, man or woman, does that mean they use the will against the living man or woman to go after their assets? Then because there's no one else that the named parties in the will can vouch for or
It doesn't.
to
It doesn't.
administrate?
It doesn't matter if there's a living will or not. In their system, everything is an abandonment, and that's all they're doing is collecting up abandonments, according to them. However, we understand that it's all RICO because they're not even supposed to be touching our property through those so-called abandonments where they had a live man give a fucking wet ink signature in the name of the very estate. This goes beyond comprehension of anybody that understands that a probated estate, when there's a living man executing his own documents, that should be reasonable and logical for any astute man that's supposed to be legislating or ruling or giving opinions on law on a bench. The realization, hey, something's wrong here. I shouldn't be administrating this case. There's a living
Right.
man on the other end.
Right. So basically, what I see, the estate or estate is the electronic record. That's the
No,
picture that I'm getting.
no,
Is that correct?
the estate, your estate is everything that you own. In other words, all of your property, all of your real and personal effects. This is all of your thoughts, all of your creative ideas, everything you've produced in life, all the way from kindergarten all the way up, that's been in record. That's all yours. That's part of your estate. If it weren't for you, they wouldn't have created those records. By putting them out in public and stating that they're public administrative documents is false. There is nothing I could be more clearer on this.
So I don't want to get too hung up on this area, but certainly if a testamentary trust is named in a will, my understanding is that a surety bond will be required unless it's specifically waived in the trust agreement. And I know that in the case of wrongful death,
Specifically waived in the trust agreement, because if your trust is set up correctly pursuant to a living will, again, it doesn't go to a public probate of abandoned property. It goes under the fact that the will is already known and is not to be executed in the future. It's being executed now because the testator has passed on. That automatically initiates the execution of the living will. So even
So
by
if-
third-party interlopers coming in and trying to administrate it when there's already a living will is a matter of violating the powers of attorney that are not there. Go ahead.
When you say testator, and in that sense, does that mean the masculine part of the one controlling the will in the way that they have it set up in probate, or how
Cor-
is it?
Well, the testator is the one in trust law that creates his own will. So again, in a probate situation, they're saying there is no will. And that's a direct violation of powers of attorney by saying, well, we don't see no will. Simply because you don't see no will doesn't mean it's any of your fucking business. It's a private
why-
estate, and if there's an execution of a will, the creditors will be paid and the property will be managed.
So is that the reason why over the years, it seems like over the years with the new deal coming in when everything was reconstructed, they were pushing that people create these wills, and they were having people to create wills unbeknownst to the position that now they were turning everything over into an administrative process. Am I correct?
Correct. And that was the new deal with Social Security Act, the IRS amendments, the Fair Labor Act, Federal Reserve Act, all of that stuff, all incorporated in indoctrination and believe that you are worthy of the government. And therefore, we're going to put you to work rebuilding the infrastructure after the demise of the Dust Bowl and the Great Depression and the run on the banks shortly after World War I. Only to prepare and jostle everybody up into believing they're these great people to prepare them for World War II so they hand their sons off to that.
So basically, these all took place within the gentleman, I think that was the president at the time was Theodore, was that Theodore?
Yes, Roosevelt. Yep.
Theodore
Ed-
Roosevelt,
Ed-
and this was
Edward
between the years,
Edward Mandel
right,
House.
right, and this was in between the years of 33 to 36.
33 to 39 total. There were a number of programs, and that's basically what we're going through now again. They're basically just restructuring things and offering everybody a new deal. That's why they're allowing all these immigrants. They're going to do a lot of you're going to see a lot of increase in the aluminum trade and infrastructure rebuilding, and pick up in steel and iron and all of that. And so they need a lot of new immigrants that are going to come in and be willing to establish those naturalization papers for bigger investments.
Right, and this is where the indemnification comes in, because now they have these immigrants to come in as indentured parties.
Correct.
Okay.
Correct. Contractors of the government. That's what the naturalization document is for, and it's actually a contract clause for immigrants to come in and pass a civics test so that they can comprehend well enough certain civics to be able to allow the government, again, to use their numbering system as a way to control and direct the credit system for their benefit.
So basically, this numbering system is the enumeration where they bring them in as like migrant workers. Am I correct?
Correct. Same thing as the enumeration at birth. That's an immigration document. Remember, folks, there's no record of birth registration in the United States, yet they are keeping records on everybody through the mayoral form of government and those fidelity bonds and surety bonds. They have to know all the residents that are under those bonds, presumably. In the court registry investment system, in the probate, that's the birth registration system at the local county registrar. That's that initial resident determination that's not qualified.
Death
Now
lawsuits
I
that
see
people
the
can qualify
correlation with the
for the sole purpose of bringing.
residency and the people, the migrants coming in.
Yep. They're here to earn permanent residency.
In the lawsuit, and they only have to put up a $100 cash bond. So I think you've covered pretty extensively where
Earn permanent residency, and they have to contract for it.
we have to get bond. Let's talk about
The enumeration at birth here for natural born people is a conference of a contracting business, and they're never taught any of it.
the surety bond
So
application itself.
basically, Keith, this is where they also bring in and they introduce to them these different certification and identifications to identify who these incoming migrants are, these indentured men and women.
Correct. All about the money in contracts, folks.
I have a form that we've used in the office in the past, which I will not try to show on screen because you'd have to need a microscope to see it, but it's very small print. But the bond, the application itself is actually 2 pages, and we're going to go through the first part of this first page, which really talks about the kind of information that's gathered. So let's talk. So let's just generally tell me, Shirley, how is a surety bond obtained?
Well, it's obtained much in the way that you obtain an insurance policy. You go through an agent. There are certain agents that specialize in issuing bonds, including bonds for conservatorships or probate or for estates. The clerk's office typically will have the names of those agents. So if you were looking to be appointed as an administrator of an estate, you could go to the clerk's office and they will give you that information. Then you contact the agent and they do exactly what you were just talking about, Richard. They go through a preliminary process, get some initial information like a name, maybe some credit information, maybe just a little initial financial information. And then eventually you would fill out a much longer form, that form that you were talking about that asks for more information and then has some agreements that we're going to talk about included along with the application.
Okay. Now, I know.
And when it comes to the indemnification agreements and stuff, this is all stuff that most of it can be eliminated by simply putting the terms in there. And again, any private information can be converted so that like a different form, just like Prince converted his name to a symbol. That way, if they wanted to use the symbol, then they could use the symbol and hide that private name. So you can do that with each individual entrance document or whatever document you're using, and replace with various different symbols. The name Keith shall now be known as the @ sign here and after, and then you just use the @ sign for everything through there. And it's just a symbolization, and that's the importance of grammar and knowing how to construct language and everything, so you can specify things so that things will be clear throughout the documentation. Sometimes you just have to be more specific.
So are you saying, Keith, that one now can alter or change who they are through symbology in order
Absolutely.
to change the record?
Absolutely.
Okay.
Or in order to create a type of redacted or codified, ciphered document.
So, Marguerite, further down in the application form that I have, one of the key questions they ask is attorney going to be involved, and will they remain involved? Tell me, how important is that as far in the application process?
I'll put it this way: we often see surety bond applications come across, or at least when I get involved, where there's no attorney involved at the beginning or at all through the process. So the bond certainly can be issued without having an attorney involved. But the importance of the attorney is,
Excuses.
with estates or trusts or conservatorships, it's not straight. It's not natural for a lot of people. They don't know what they necessarily need to do.
So again, they're pointing out that people just don't know what they're doing. So again, I urge people to learn what to do. They're telling you right here. The importance of an attorney is because the people don't know. Woe ye lawyers who have taken away the key of knowledge.
And so they'll want
They are not important. What's important here is you educate yourself. Go ahead, sister.
So Keith, the thing I'm thinking about with the introduction of the wills, and then they're having specific people named in the will who is going to be executor or executrix, are they now making them the trustees unbeknownst to documents that these attorneys can create without the knowledge of people uh, in that process?
Absolutely. And again, that's the importance of knowing the information and how it works. Um, when you start assigning these, an executor and the beneficiaries and things like that, and you're actually running an estate while you're alive, um, you have to understand how that the revocable trust, and you can change that revocable trust through your lifetime. It's a lifetime trust, and in that, you change up the parties. When it comes time to die, and you know you're coming close to your death, that trust, again with the living will, you've got the executor all set up and everything. It should never go into a probated case. The attorney should never know about it. That's what they're saying here, is that a lot of times you need an attorney because you don't know what you're doing. If you know what you're doing, there's no reason for an attorney or the public record to be involved at all. And that's the problem. Woe ye lawyers, you have taken away the key of knowledge, and the key of knowledge to keep your business private. And as soon as you hand it over to an attorney, they take it as an asset because you don't know, because you didn't qualify anything. You hired them for a representation. You didn't qualify the signature, this and that. You were never taught any of this. This is why it's important to learn about estate and trust planning.
So Keith, the question, well, it's not really a question, but it's a deduction or a deduction that I have. In this sense, when you have a will, there's no one else in the will. Like I said before, say people that are named in the will as specific parties to administrate certain process are no longer. But right now, they're having a lot of kidnapping going on of people. And in the kidnapping, they can state or try to state that someone is incompetent or that they have some kind of a mental capacity. Now you have those people in a position of these attorneys to now administer someone's estate, like you said, through these will. Is that not so?
Well, yeah, but that's why it's important to keep your will and estate matters up to date. So if you have somebody that's part of your trust and they pass on, you've got somebody else that you can fill in that position if it needs to be filled in. Particular an executor. If an executor passes on while you're still alive, you need to assign a new one immediately. Because if you die without it, that's when the state steps in and says, well, there's abandoned property. And they've got every reason to do so.
Now that could be where you can create your own will. You don't need to use one that was created for you through an attorney. Is that not so?
Correct. And that's why I urge everybody to learn this. Learn how to establish your own living will. That's the beginning of establishing the express trust. It is an express trust. And if your living will is done right, and it shows the structure of your trust, it doesn't have to qualify through trust terms and all that. You don't have to use specific legal language. It's all scriptural and spiritual. It's an ecclesiastical trust that is already there. Every word of God is pure, and it is a shield unto he who put their trust in God. In God we trust. It's a lot more important than what you think.
Now I see why they have that specifically on the dollar bill. In God we trust, because everything is created in trust because everything is based on credit and debit. And that's how the system, what they call the monetary system, is a credit and debit system. And that's how everything is being moved through the system.
Absolutely. It's all based on the word. Your word is your bond. If my word is my bond, why do I need a surety bond? Why do I need a fidelity bond? I don't. But I've got these receipts that say I can obtain indemnity.
Advice of an attorney to help them make sure they're meeting deadlines. There's certain things that require court approval before you can take those actions that can ultimately come back to, I say, haunt you if you don't get the court approval before taking this action, and that could impact the bond. And so the bonding company will want to know, do you have an attorney? Is someone going to be helping you with this? And you know, if so, they're going to be involved along the way, because that could help, and we'll get into this later, but that can help stop at the beginning potential issues from arising.
Okay.
They can stop potential issues that begin rising. No, again, it's their delusion and their confusion and their grandeur of thinking they know what they're doing and taking the matters into their hands and entering them into a probated matter and hiding the key of the real knowledge of taking the matters into your own hands and executing your own will. Very simple language, folks. You don't need all the legalese.
Well, there's much more information that's collected in the page 1 of this particular application form, which I think is fairly typical. But let's jump ahead to page 2, Shakrisha, and let's talk about the document that really is the enforcement tool that is used should a surety bond be forfeited. And that's the indemnity agreement. So can you please explain for our audience, what is an indemnity agreement?
So we find we have fidelity bonds and surety bonds that don't have any enforcement unless there's an indemnity agreement. So if you're a third party in one position or another, there should be an indemnity agreement. Again, equity acts in personam. This is your door to create your own indemnification agreement, which is in contract form, so that if you're harmed, damaged, or caused injury or loss, that you will be compensated appropriately under the Fifth Amendment. Any other amendments that might apply.
Sure, Richard. Well, you know, as we talked about at the very beginning, the bond itself is a three-party agreement between the surety, the principal, and the obligee. When a surety writes that bond, the underwriters expect that they are not going to incur loss, unlike an insurance policy.
So the indemnification agreement is merely a document that we can put forth to be identified as the obligee, so that they no longer require us to identify. They understand the record now. See, that helps balance that record. That's what we're looking for.
Even though they've agreed to guarantee the performance of their principal, which means that they might ultimately have to pay some money to the estate. And the way that they prevent a loss from happening is that the principal signs what's called an indemnity agreement as a part of the application process. And that indemnity agreement provides a number of things, but at bottom, what it does is it provides that the principal agrees to indemnify or pay back the surety for any loss that it might have as a result of having issued the bond.
And in this case, we're not supplying a surety. The surety is already there, and we're qualifying ourselves as to be indemnified in case they violate the surety that's already there. That's that birth certificate that's under full faith and credit of the United States. Because in order to violate that surety, they have to violate us. That's the violation. That's what prevents them from going to the surety and getting that access and using us as a swap condition or swap imposition, as if though we don't know what we're doing, which we didn't. That's why, again, the learning is so important.
So Keith, basically these courts as administrative courts, this is where they made it appear to look like they are judicial courts, and judicial courts are under Article 3, whereas these administrative courts are under Article 1. And then this is where they can really take advantage of the people in the way that they have, because it's a mirror effect that they have created. Is that not
Right.
so?
Right, because they're presumed to be prejudicial courts. And that's why when we sign, we're supposed to qualify without prejudice, without recourse. We're not in contract, and there is no prejudicial determination. This is not up for assessment yet. You have nothing to assess. You have to get it from me. I'll make that assessment. This is the problem with the situation with Trump, trying to get Trump for that $3.5–4 million fine or whatever, saying that he was manipulating and defrauding somebody, when in fact, no, he was giving his own assessment. And that's what qualifies a privity of contract, is the equal consideration and equal benefit. And in that, that's how we negotiate. We give back and forth assessments.
And we'll talk a little bit in a minute about some of those details.
Sure. And I will say that the whole back page in small print, again, you need a magnifying glass to read it, has all of these different types of agreements that you as the fiduciary are agreeing to be bound by. And Marguerite, in that regard, one of the big things at the very beginning, of course, is that you represent that all the information you give to the bonding application on page 1 is true and correct. So you better make sure that you're accurate when you say something on the first page. But then second page, one of the key provisions I want you to talk about, Marguerite, if you could, is can you explain the importance?
And when it comes to those terms, conditions, if you take a look, and I posted it in the community in 4 parts, my statement of separation, that would be pretty close to what an indemnification agreement might look like for me, in my perspective. You know, aside from the fee schedule, there's no fee schedule attached to it, which I'll put up one of these days. But that statement of separation, that's going to show the points of their public record keeping. I might throw in 5 CFR 2635.101, basic obligation of public service, as well as 5 CFR 575.102, where it gives the definition of agency, administration, competencies, employee. Federal government means all entities of the government of the United States, including the United States Postal Service and the Postal Regulatory Commission. You know, so think about that. And again, we're going to be going over, I've got a couple things pulled up here for another video, or another stream here. Contractual indemnification of government contractors, and the indemnification under 10 U.S.C. 3861 fixed price, and that's the military. 10 U.S. code is military. So we'll be taking a look at those in the future.
Of the provision that says that the fiduciary will exonerate and indemnify the surety from all claims, losses, and so on and so forth, which is collectively called a loss. What are we trying to cover there?
What we're trying to cover here is the full range of potential monetary expenditures by the surety as a result.
Austin Murphy says something blew his mind. What blew your mind, Austin? Leave me a comment.
Of issuing this bond. So in simple terms, for example, let's say our principal, our fiduciary, let's say the executor of an estate, has not filed an accounting for many months or years, and it looks like money might be missing. And even if money's not missing, we just don't know what's going on. And so what will happen is we might address this a little bit later on in more detail, but what will happen is the surety will usually get notified by the court or the commissioner of accounts that something is awry. We get pulled in. And if the surety has to hire outside counsel, sometimes
so what they're saying is, when one of their nice policy officer comes along and issues that civic citation, that civil citation, that traffic citation, they enter it into their books as a debit. So now there's something that's out of balance, and we're supposedly the surety, and now we're supposed to go in and settle the matters or account for the imbalance. See how they swapped everything? That's their job. And it's when we give in and give those data elements because we don't know, it's placing a public liability on the record. This is an accident under 49 CFR 378.5.
Courts require the surety to send a representative to court.
Definition of accident, 49 CFR 387.5, I believe. I'll look it up just to make sure.
Then, like someone like me or Shakrisha, then that costs the surety money. And so even if there's not a lost ultimately in the sense of the money wasn't stolen from the estate, but the surety still had to pay an attorney to show up and protect its interest in court. That can come back and be charged back to the bond principal and the fiduciary of the estate to have to pay the surety company back.
Well,
And so the purpose is to be very broad and cover all those instances.
So it's very important for fiduciaries to understand then that even though they haven't necessarily been charged with anything yet, if they don't respond to inquiries about why they haven't done something, and bond counsel has to get involved, then bond counsel goes on the clock, and that clock is something that they're going to have to pay for. So as we'll talk about later, it's really important to be responsive to notices, especially from the Commissioner of Account and the court. Sure, Krisha and Marguerite, I want to go ahead and turn, because I will come back and talk more about some of the provisions in the indemnity agreement in part 2, because there's a lot to cover there. But let's talk about some of the common problems.
And while I'm thinking about it, you know, as I mentioned, it's the district court, the county court that's holding that probate account through the registrar. That's that original court where you were born. Okay, the county that you live in, they have some probate records too, but those are from the extended record that you gave them upon becoming a resident in that territory and stuff. Your driver's license, state ID, whatever it was, your utility bill, you went in and showed them your ID and gave them social security number, all that stuff.
So Keith,
So,
the question
so I
that
hold on. So I imagine a good place to qualify an indemnification bond would be with the original birth county. Go ahead.
So, brother, that would mean to me, I don't know about anyone else, but what I'm literally seeing or hearing is that all these administrative courts, if the clerk and the which is the CEO and that these head officers like the prosecutors and the district attorneys and the governors, if they are all in bed together and they're assisting to administrate these records in some form or fashion, they all should automatically disqualify themselves or be disqualified because they are doing something unnatural to the children of Israel.
Right, and that's what we're doing here is in this education, we're going to help disqualify them through the education. Once more and more people catch on to this and understand what the enumeration at birth is all about, they'll be able to appropriately rebut it at the hospital and still be able to use the hospital services, just like any other foreigner.
Problems and pitfalls. You guys have been doing this for many, many years now.
See, what happens if a foreigner goes to a United States hospital and gives birth? Do they claim that child as a United States citizen? No, they can't. They have to admit that that person is foreign. They can check and see where they're from and you know, find out if there's some kind of tax agreement with them through the international forum that says, hey, you got to get this birth certificate from your home country, you know, whatever. But the United States can't force them. That would be interfering with a private international contract with their home country. Go ahead, JG.
I missed a little bit. I had a conversation with the lady. How's Israel involved?
Israel is still just a corporate entity. Back 1947, 1948 is when it was created.
Yeah. Okay,
I mean,
I heard Eamon bring up Israel, and I was like, whoa.
Oh, yeah, well, she's talking about the biblical Israel.
I got you.
Yeah, but one of the things, Keith, that I'm also noticing, if that is the case with the United States and they are having international contracts with all these other nations, that means these nations have a contract with the United States in order to participate and utilize this foreign currency so they can actually participate with one another and exchange products and services between themselves. That's what I'm seeing.
Yeah, it's the international harmonized tariff system under Her Majesty's Royal Warrant Holders Association and her labor union, Universal Postal Union. It all goes back to the international forum of everything posted. All events accounted for throughout everyone's life, they want posted. They
So
don't want
Keith,
the privacy.
would this fall in between, I think it's 93.1 or 2 or 149.3 under Title 19, customs?
Absolutely. That's those data elements. Everything we're taught in these public schools, we've never been taught how to use the data elements accordingly in this civic venue. We've never been taught that the Social Security number is a system, is part of a system of numbers where the public officials, as public servants in a public trust, through authorizations, delegate and direct the routing of the funds. We've never been told that funding is because the data elements that we give them, those data elements are converted in their system one way or another, here and there, all over the place, into a value system. A value system for contracting. That's what all the statutes and everything are. Those are contract terms and conditions with their penal sums and various different licensure costs and insurances and all that.
Right, and this is where they take these statutes and they use it in the civil sense of the civil activities, and they show you all these benefits that one can acquire, and that's what they're doing, the exchange of information. They're taking the elements, exchanging for information, use those data elements against you, while they are showing you that you can receive benefits. That's where I
Yep.
see the scheme comes in.
Yeah, that's the bifurcation and swap. They switch everything around now. Somehow you're supposedly liable and supposedly logical, reasonable, and know what you're doing and intended to do so. Ain't none of it true.
Now, isn't that bifurcation to a military practice? Because since everything is under the military,
Bifurcation is just merely splitting of a title.
right? I know it's the splitting of a title, but then if someone is out there saying, I can remove you out of the system, and they're saying they can bifurcate you, which is a removal through out of this corporate system so you can be a private man or woman, that's what they're utilizing because it's still connected to the process of military.
Right, but
Am I
see what
not correct?
right, but what happens is if you're going to do that, that kind of bifurcation is just an extension of another of their creations. In this, the indemnification and redemptionary, we're taking possession of that entity, and it's no longer going to be known. It's going to sit in private placement, and everything's got to go there to have any effect in the public domain. It's got to go there first. That's the first directive. You got to check here. This is where it's here's where it's actually hooked to the general ledger, and it can't be put out of balance. If it is, it's the Postal Service responsibility to research and resolve it within 3 days. No one else's. That is the Judicial Officer Department, which is a independent and neutral forum within the United States Postal Service. It's already done. You don't need the judicial officer. You don't need the administrative law judge, and you don't need the Postal Service Board of Contract Appeals. It's as set. That's the asset. Put the
So
title in the right place.
okay, well then, Keith, would that mean in your last video you did recently about the AP, it was dealing with the Constitution, does that mean any documents created would have to go through them to be, any errors to be corrected?
Absolutely. It's got to go through the trust. The trust is established here. It's with the Postal Service, and they're the trustee. I'm the owner. They're the trustee. Ah.
So which constitution would be more relevant, the postal constitution versus the United States Constitution? Which is more appropriate to
Neither.
follow?
Neither.
Okay,
Neither.
okay,
You're
okay.
creating your own you're creating your own foundational documentation in the same form, an international trust. It's already there. The International Global the Global Postal Trust Services. It's already there. That's why they have the Real Estate Investment Trust with the SEC, not the United States. It's the United States Postal Service. They're the registered agent already.
And based upon what you've seen so far in our show tonight and what you've learned over the years of your experience, what are some of the common problems and pitfalls that applicants can encounter?
Oh, Richard, I would say that, the one that's come up most often for me is that some of these applicants are inexperienced in handling financial matters and don't.
Again, they don't know. They're inexperienced in handling these financial matters. Again, that's why it's so important to learn this stuff. You keep handing it over to somebody else as a matter of comfort and convenience, and then crying about how come you've got to pay so many taxes and how much your fees, your registration fees are, and how much your insurance costs. And come on.
They may not even have had to balance their own checkbook, but then they're put in the position of having to manage someone else's money. And I think sometimes not having that experience can pose a problem in the application process. It also can pose a problem at the end of the day in just how the estate or the conservatorship is managed. So having some financial experience, I think, is helpful both from being able to get a bond as well as being able to manage some of these estates.
Marguerite, how about yourself? What are your observations about some of the common problems you see applicants encounter once they've been bonded?
I would echo Shakrisha's comments, but take a step further and say sometimes I see, you want people who know the decedent to get, and I say this decedent or conservatorship, you want people who know the family to be involved in this process, because who knows where all the skeletons are better than your own family members, and who has the best interest? Generally, you would think family. And so even if I don't want to, it's important to have a financial background, but that shouldn't scare people away. The first and foremost is to be communicative and organized and just track money in and money out and keep receipts. And that's where a lot of people get in trouble.
Keep receipts. Those receipts are so important. One of the important lessons I learned from my father, him and mom both worked for the federal government all of their life. Towards the end there, though, the last portion, last half of his life, he's still alive. I mean, last half of when he was doing business. By the time he turned like 30 or 35, somewhere in there, he switched up and was working for the Blackhawk County Assessor's Office. And instead of working for the county assessor's office anymore, directly, him and another guy went into the real estate appraisal business on their own, privately. But the contracts that they sought were all government contracts. And in that, he started keeping track of, he very well knew the tax system and how it worked accordingly. And he kept track of every receipt. And this man wrote off everything. Everything as a tax issue from a private business can be a write-off. Everything you buy can be a write-off.
Exactly, Keith. It can be, but now, but then in coming into now, what they've been doing and that I've been noticing over the years, and this is just from what I'm seeing, is that they've been restricting more and more what can be deducted. At one time, you were able to do those things, but now they place restrictions on what can and cannot be within your wage bracket in what you bring in as a wage, because they still have people conditioned to make them believe they're under income of receiving some kind of a monetary income, but people don't realize it's all wage earnings. It's different. It's not the same. It doesn't equate to those things, where income is based on business and wage is based on your labor.
Yep. And that's, another great example of a conversion in language that people don't comprehend. And when we look at the definition of income, there's various different definitions of income too. Annual income, gross income, net income, this and that. So when we look at those, we find out everything's a conversion of a gift. Tax literally comes from the term tithe, which means gift. So if it's a gift, why would it be demanded? It's voluntary, folks. I assure you.
And the other thing is to ask for help when you need it. And I say this because too often I have heard from a bond principal, it was my father. I didn't have the emotional capacity to deal with his estate. I'm still dealing 2 years later with his death. And that is perfectly fine. We get this. This is a very tough part of your life that you're going through.
Technically, according to the Lord's release in Deuteronomy 15, you have 7 years to clear out with creditors. If not, there's a bankruptcy process.
Understandable, but you also agreed to take on this role. And so if you need help, hire an attorney.
Which is the 7-year indenture, and that's why bankruptcy uses it themselves. Once you file a bankruptcy, you can't file another bankruptcy for 7 years. You're supposed to indenture yourself into a financial system so you can learn it well enough so you don't go bankrupt. If you do it and you last 7 years and still haven't figured it out, guess what? You get another chance. Ask Trump. He's done it 7 times.
Or come forward and say, listen, I am not capable of doing this. I'm just not emotionally there. I don't have the financial background. And more often than not, a commissioner, the bonding company, we can all come to an agreement to have someone else step in and take over with very, very little implication for you under the bond. And that's important, just recognizing your own personal limitations and coming forward sooner rather than later. Because if you put it off, that's when it snowballs and things can come.
And that's what we're talking about here, folks. The more you put this off, the more you put off teaching your children at home, the more you put off making your life better, the more you put off improving things that will not only help you, but those others around you, the more you put off being humble, the more you act in your self-centeredness and think it's all about you, the worse it's going to get. You have to learn how to, you have to learn yourself. Otherwise, nothing around you is going to change. Go ahead.
Well, Keith, the one thing I'm seeing, like what they talked about the scripture, there's mothers against daughters, fathers against sons, you know, those kinds of things. But what I'm realizing now is that for a lot of people who are becoming aware of what's truly occurring, that's the reason why, to me, they have implemented these cell phones, because now they can work on your frequency and they can, you know, focus on the mind control, so that for the people who are aware and for people who are not aware, you're not communicating, you know, these things and that's where I think it comes into the scripture where it talks about principalities in high places, because now this electronic communication, it's detrimental, and this is to me why they instituted AI. I mean, that's how I feel within my soul.
Yeah, but we've got to remember again, folks, we are the ultimate. We make every choice we make, every breath we take. Well, we can choose to not take a breath. My sister did this when she was a very young girl. Decided she just didn't want to take any more breaths. Held her breath until she passed out. Guess what, though? Unless she did it a different way, she ended up taking another breath. That's His will. And every breath should be an act and deed of Him. If it's not, then you're probably acting in some kind of selfish way.
Yeah, but isn't that mind control right there, what you're saying?
No, it's a matter of freeing your soul, understanding that you control your own mind. Every breath you take, you have control of. Use every bit of power you've got and know that you're not the most powerful. So where are you getting that power from? That should be your that should be your inspiration. Is that something greater? That's what makes your actions so great. It's not your merits. It's what goes through you. And I'm every time I got mad and I reached for something that to help me take out a violent aggression, to quell my anger, I realized myself it wasn't doing me much good punching walls. You know, I broke my hand enough times. So we really got, yeah.
I'm just tired, dude. I keep hearing people talking about God and Jesus left and right, man, and I'm tired of hearing that shit.
Yeah, and understand, I don't want to be hypocritical or anything, but at the same time, I'm not the Jesus guy you might think I am. I'm using the principles. I don't know if the guy really existed or not. I can't say. I can say more than likely he did. But in that, I also have to understand that those scriptures, they're kind of redundant according to a lot of different cultures throughout land and time. You know, you maybe go back and look at the Anunnaki and things like that, and various different story of Gilgamesh. A lot of them look kind of similar. So it's not so much the character, again, the messenger. You could call him Tom Thumb if you want. You can call him Jesus Christ if you want. But the true principle is the message behind it. I don't care
Yeah,
if you call him Buddha or Allah or God or Jesus or even Satan, for crying out loud.
yeah.
The
The way I
prin-
look at it is it's got too far with the Jesus. So it's like, why even keep using that name? Because it's the
well, it goes to the principle that if even if there's no Jesus, particularly, wouldn't that also then mean that you are your own ultimate authority? Synonymous with the scripture that says, "Ye are gods. Ye shall do greater things than I." Why aren't we? You know, if Jesus was walking around healing people, why are we not doing that today? If that story is true.
it's a belief. I hear what you're saying. I'm just saying
Yeah,
it's
so it's
like
yeah,
it's
so for me it's
2024 and whatever, man. It ain't shit.
yeah, it's the principles, you know. And this is why I talk to people about the law of nations. A lot of people want to talk about the law of nations, but most people don't want to mention what it's otherwise known by, and that is the principles of the laws of nature. So isn't it inherently more important to act naturally in yourself and listen to Mother Nature through your observances?
Right,
I
and there's
think
a
that's
better way to go off of psychology, mind and behavior, rather than going off of Jesus, right?
yeah,
The
and I
whole
think
Jesus
that's
thing
what
and the God thing is like the military. It's like, what we're talking about with this military, the machinations and whatnot.
right, and I think that's part of what Jesus was teaching with psychology. When they asked him if he was the savior, he says, "If that's what you say, you know, it's your psychology. What do you think? I'm not here to make any such false claims. I'm only here saying I'm the Son of God. Ye are
Yeah,
gods just as well, you know. We're all children of God. We all recognize that as a basic principle. So my concept or my query is, why would they even concede that that would be a problem? Because didn't the Pharisees them too see themselves as children of God, just like the scripture said? So because he said it a little different, all of a sudden they have a problem with it. See, that's the thing about grammar. You can say a lot of things different ways, but generally everybody's saying the same thing. And I don't think anybody has ill intent in their heart when we're born. I think that's derived after our subjections in life through the insane people we have to deal with.
that's where intelligence comes in.
Yeah, that's why I say I've been telling people since I was a little boy, fuck you, you ain't my daddy. And it wasn't because so much that they weren't my daddy, but the concept that I knew if my daddy was around, in my heart, I felt he wouldn't allow that kind of shit to happen. That was just in my heart. That isn't how my daddy actually acted.
Yeah.
Bigger problem than what they
I
could have
just
done.
the propaganda
I
is a
couldn't agree.
divide. That's all I'm getting at. The propaganda
Oh
is a
yeah,
divide. That's all I'm getting at. Just like how racism is a divide and conquer mentality, I look at the propaganda with religion and whatnot. It's not good, and people still go off of Jesus and whatnot. But it's like, well, look at all the propaganda. Look at all the misinformation. Look at the divide. Look at the big picture. And why
well
are we
yeah.
still using this name? You know?
When we look at Hinduism and Buddhism and stuff, and there's a lot of similar stories. Jesus, like I said, just like it's a repeat. Siddhartha, same
Yeah.
kind of same kind of being, just a different culture. So it's not so much the messenger again and what their name is, Jesus, Siddhartha, whoever, but the message itself and how they live their lives. Very
Right.
distinct difference. And it goes to that moral concept. Most people should have it, and it doesn't seem like they do.
All right.
More margarita. Certainly, we've seen in our office, and what we encourage folks, is that you can do the job. You don't need to be a special skill, but you have to be able to at least balance a checkbook and keep good records. And more importantly, I think, as you mentioned, don't be afraid to ask for advice. I mean, that's why you have, accountants and lawyers and CPAs, and they can guide you to make sure you don't, fall by the wayside as you try to do what you think is a good job. Well, we're running out of time, so let's go to some closing comments. Can you share some final thoughts and words of advice and practical suggestions regarding our discussion tonight about the surety bond application process and what people might want to consider doing as they undertake this task of being a fiduciary? Shakrisha, you want to start?
Sure. Well, I would just say it looks like a lot on that application, but read the application and understand what you're getting into with respect to the obligations that you may owe to the surety, and reaching out and either talking with an attorney or even the agent who is helping you apply for the bond. They can talk you through some of those provisions and help you to understand essentially what you're getting into. And I think that before you take on the task, it's good to at least know what those obligations are, and reading the application is the first step towards that.
Marguerite, how about yourself?
And so when it comes time to talk to the Iowa Travelers Insurance Company tomorrow, one of the things that I'm going to request is a copy of the bond information for the city of Waterloo, so that I can give equal consideration as the third-party benefactor. So as part of a negotiable instrument, I would have information directly from the holder of their fidelity bond that would allow me equal consideration with infidelity with who they're holding a fidelity bond for. And that, again, that fidelity bond seems to be specifically for the Postal Service, whereas the surety bond is for the public servants of the administration. So the fidelity bond is like a fealty bond, and that's the fidelity, confidence, confide. That's the military side, whereas the surety bond is the administrative side. Again, according to my perception in this research.
Keith, you mentioned something about when a police officer apprehends or stops someone, they make a sudden arrest of someone. You mentioned something about them putting some kind of they put in their recording of a debt. Could you how did you say that earlier that is done?
Yeah, they use a traffic citation for whatever kind of penal sum for the infraction, and that goes into their administrative courts as a debit. And they create an asset for themselves because they're saying they are owed, that they have a debit there that somebody owes them. So now it means there's an asset for them. See, if somebody gives them a credit, then it's a credit. It's an investment. And the investor is known as a creditor. They're entering you in as a debtor. And in that, they take that and create an asset on their side that they can then invest, but they invest it in your name as a debtor under the firm name with obligor number.
So Keith, say for instance, because I heard a story before, and I don't know if it was through you or whoever, someone was saying they were kidnapped, and they said through the police department. Now, if they're entering that as a debit, like you said, and then they make you and you're really the creditor extending credit to them where they receive an asset, then does that mean this stuff is incentivized? Is it incentivized when a particular officer becomes at a certain level and he reaches this knowledge and he can use that to his benefit against targeting specific people and
Well,
using their information in order so he can create assets to benefit himself by using their information, if even though he does not have identification for the man or the woman or whoever he's apprehending?
I don't know. You're thinking way too hard, sister. I don't know what they're doing in those kind of aspects. All I know is the information I've got says they converted the last name to a firm name and the obligor or the social security number to an obligor number. With that, I've researched and I've learned enough to know that what they've done is they've taken a instrument that is created as a debit, entered it into their system as if though it's a credit for them because somebody now owes them through that instrumentality. In that, they get to invest it for the interest. On that interest, there's a credit default swap. They're naming you as a creditor and defaulting on it, and now they have an interest. They're bearing an interest. That investment is in an interest-bearing account, a mutual fund.
But okay,
I
because
would,
the reason I'm going with that, Keith, is because I remember you talk about that particular form where you said that the defendant is the creditor. So when they're doing this and they're using these statutes to do that through these penal codes that they're utilizing, isn't that what they're doing? So they can have the
Yes, there's
opportunity to create a business opportunity in that sense?
yes, and that's why I said they're swapping everything. If the defendant is actually known on that form as the creditor, then somebody has swapped it by saying that the creditor is the one that owes anything. If I'm the creditor, then how is it I am named as a defendant and led to believe that I am guilty of a debt?
So how would one be able to, because that leaks like it's fraud upon the court, and through the risk management position that these officers that they think that they have an employment is credible, and they're not, because they're using the United States and these instruments as what they would, to me, would appear to be indispensable parties.
Absolutely. That's why I'm saying if they issued a failure to appear for jury duty, and I have not been employed for 8 years, where is the business that they are trying to contract with to say you have to come in and sit in jury? There isn't one. So their process is fucked up by admitting that they're trying to use me as an investor, as a business, a corporate investment. I've already beat them at that game.
But it seems to be like the practice you're utilizing now for a lot of people, because they created a scenario where now you have a lot of people out there in the streets, right? They give them a specific title as indigent or homeless people, and now it's like it's something they created to prey on these people because of the system, the way it's set up.
I don't know. It may or may not be. All I know is the record I have says they don't know what they're doing.
Yeah.
And that's why it's important to learn what's supposed to be done and not let it be done any other way.
say that be organized, really into organization. Just look at if I could show you my office right now, you see there's highlighters and matching Post-its. We're not saying that that's what you need to do, but be organized, keep track of what you have, and just recognize no one's going to blame you if you choose not to be the fiduciary of an estate, if you don't feel up for it after you've gone through the process. But once you decide to do it, you need to communicate and be organized and keep track of where money goes, your asset goes, and your receipts. If you spend $1 or you have someone take some stuff to be donated, just get a receipt and keep that in.
And that's part of the problem. They're not supposed to be holding you liable against your own estate. First of all, in a probate situation where they have no jurisdiction over the estate of a person who is in fact alive. Second of all, if there is a fiduciary position, then they have to show a true, valid contract with willfulness, knowingness, and intent. They don't have any of that. Nobody's been, like she said a couple times now, they don't know this stuff. So it's wise to get an attorney. I'm suggesting it's not wise to get an attorney, as they say. If you're going to hire an attorney, you hire them to further the research you've already done to make sure you're not sounding stupid. In other words, you find objective views to correlate. You don't hire them to make a representation in an administrative court or The military courts.
In place that
Well,
when it comes time, people can help you. And talk to an attorney, talk to the agent, and the Commissioner of Accounts offices throughout the Commonwealth are very helpful. I will say that they go above and beyond to try to help fiduciaries with compliance, and that there are resources there. And if you just start off strong, with the right foot forward, then it won't.
With compliance. With compliance with what? Administration of probated estates or the living will? See, when it comes to the living will, they have no powers, let alone to say that you have to comply.
It's not a hard
so Keith,
process once you figure out what.
just like
Yes.
you said something earlier. I was listening to one of your recordings and you mentioned something earlier about doing a publication. Would one do a publication in a newspaper and put it out there that blase of what you're discussing today, and would that be letting them know that you're aware and this is your intent without giving them any documentation, any express written documentation?
Yeah, if you want to give them some kind of public notice, it's fair to do that. But rather than do it in a paper, that's something more along the lines of the emails. Board of Supervisors at your county, the mayor at the city level, the Department of State at the state level, Department of State at Bureau of Consular Affairs at the national level.
What that process is, and you stick to it. It's like setting a routine. Your alarm's gonna go off at 7 a.m. every morning. That's just approach it in that kind of mindset.
Well, I want to thank Marguerite and Shakrisha from the law firm of Watt, Teeter, Hoffer, and Fitzgerald for taking the time.
So, and that brings us to the end of the first one, and we're at 10:48. So we'll stop for tonight and continue on with the next one. I don't know if I'll do it tomorrow night or wait until next Sunday night. I guess it depends on what the views and everything are afterwards. I was thinking I'd do the insanity clips Monday through Friday and go over that with psychology research and see if I can't get a bigger input on platforms there. And then do this on Sunday nights where we're talking about the bonds and indemnification and all that. So depends on what the response is. In the meantime, what do you guys got? You guys got anything to say about what we've gone over tonight?
Yeah, the only thing I want to say, Keith, is that I know it's been generational indoctrination that's been passed on from families to families. What I've been seeing with my own eyes, I've been seeing a lot of families being separated, whether they choose to be separated, but now I'm seeing they're having a lot of big families now all over the place. You don't have them concentrated as a community in one place now. And
Yeah.
with this type of thing, to me, it would be outside of what, is being put on your platform. Maybe it would be something that could be done in real time where people can meet at these council places if someone is willing to show what is truly going on, so these people truly know. Because I think if you cut off the head through these administrative courts and to show them what is truly going on, I think that's when it will stop. Because a lot of people will say, I didn't sign up for this. Because to me, it sounds like genocide that they're trying to reproduce and remanufacture.
Right. And rather than looking at it as cutting off their head, it's becoming the head, becoming the man or woman that you're supposed to be, and heading your own direction and directing yourself in life. And that is the throwing off of the government, and that's that covering, that insurance. They covered you up, they insured you, and you shed off that government, that false cloak, and you walk forth in the full armor of God. That's the way I look at it. I don't need to behead anybody or decapitate them or take their head off. It's just a matter of showing who's under what helmet. Again, it has nothing to do with me, and I'm not going to judge them to my best ability anyway. I'm going to stick to the record and say, hey, it just needs to be corrected. That's my outlook from here on out, and that's why I said, I've got this appointment with the IRS here. Where is it? June something. June 11th at 11 o'clock. So I'll be keeping everybody up to date with that. And just like I said with the traveler's insurance tomorrow, I've got a set of questions I'm going to be asking them. And same with the IRS. I've got a certain set of questions I'm going to be asking them about the information I've got showing the conversions and everything, and what the difference is between the Social Security number and the obligor number, and why they would remove the dashes, things like this. It is a taxpayer identification number. So think about that.
Yeah, I got a question. I've been watching, I've got into psychology and whatnot, and I've been watching documentaries and, finding good good videos. Do you know if there's any videos on what you're talking about? Any documentaries or anything that you saw that was worth talking about?
A couple of the best, I'll have to see if I can find them again. Might only be through the Wayback Machine or something. But Mr. Van Buren in the late 70s exposed the government CAFR accounts, and Mr. Daly exposed the mortgage fraud through the banks. And they're all pretty much the same thing. It's done through the manipulation of the various different terms and grammars of the jurisdictions. And when we remember Enron and the housing mortgage fraud, they were doing mortgage swaps. Well, they supposedly fixed all that, but what we run into now is that they're still doing the mortgages, and people didn't learn that those mortgages were false. So they're still doing the mortgages, and they can't do the mortgage swaps because they know about that fraud now, but they don't know about the real fraud yet. So instead of doing the mortgage swaps, what they did was now they've converted to credit default swaps. And this is where the mortgage is split from the promissory note, and somebody buys the mortgage, and it's obviously in default, so they get an insurance on it, and that insurance pays out depending on the maturity, whether it be a 90-day maturity or 1-year maturity. Most of them don't go much longer than that. They're very short time securities that pay off as an investment for a credit default because the creditor doesn't know, and he's defaulted. It's a bifurcated title. It was split. The mortgage was split from the promissory note. Both of them were sold independently without a warrant. They're both lies.
Dude, I really hate this shit. I hate learning about it.
So Keith, then would you say that in the note and the mortgage have to stay together?
Absolutely. All the
Attachment
documentation is supposed to be attached, is supposed to remain attached. If any piece of it becomes detached, sorry, it's no longer any good.
Yeah, it's a
Greetings,
system.
Imperium Privatus. Greetings, Imperium Privatus.
Greetings. How are you guys doing today?
Good, good. We were just on our way out, though. You got something on tonight's stream?
Yeah, I was just came to realization. You know how you're talking about how the name is the firm name and they do a conversion, and I came to a realization that everything we do, we practically abandon, and they're just salvaging the rights, titles, and interest to that property and doing those conversions.
Right. Yeah, that's why I said it's a salvage operation, and it's a United States vessel that's been abandoned, and they're trying to salvage it for the salvage rights. If you take over that vessel and surrender it back to the United States, you're the salvage. You're creating the salvage. That's the indemnification. You're allowing them to extend the credits accordingly and let things circulate instead of creating a debt.
Let me ask you something then. can the indemnification, would that not be the process of appropriate endorsement, notice, special tender, special deposit, assignment, and transfer of the charging underlying instrument or obligation? And then
Yep.
on top of that, noticing, appointing, acknowledging, and accepting of the trustee that
Yep.
instrument is going towards?
Absolutely, and that's why I say I think it's a matter of transferring the title to the Postal Service. They're the ones that are directly tied to the general ledger, to the master trust accounts, and when we establish an account through them as a private entity at the international level with a valid express trust, revocable, we can start contracting in form with the Postal Service, and that's the indemnification for the fidelity bond that they hold as an interlocal agreement with the tax treaty. We're able to take advantage of that as a third-party benefactor. I'm not going to dispute it. I think they're doing a great job. I want to help them do an even better job. Free stamps for everybody. Learn how to make your own. People think I'm silly. I know how it works. I've got evidence of it. I've done it myself. Local guy doesn't want to understand it. So I'm having to go through extreme measures, but one of these days he's going to understand. So I say again at the beginning of the stream, there's a difference between a surety bond and a fidelity bond. Let me pull that up real quick.
I just want to
Bonds,
say thank you for the insight.
you bet. Bonds, I want to make sure I didn't forget this. I almost walked out without doing it. Like I said, this is where we find the fidelity bond definition. This is U.S. Postal Service. You notice the registered mark there. They are the registered agent already. And it's your one-stop shop for banking, bonds, insurance, and taxes. Every Federal Reserve note is some type of bond. It's a promissory note. That's a type of bond. It's bonded with somebody, specifically United States and the Federal Reserve. You see the seals on it. Okay? Read down here, it says, tells us all the bonds. Bond is a written instrument executed for the benefit of the Postal Service as security for the supplier's obligation and to assure payment of any bonded loss. Bonds, other than bonds required for construction contracts and performance guarantees, should only be obtained when needed to protect the interest of the Postal Service. Okay? The purchase plan must describe and explain any requirements for bonds and performance guarantees. They're the registered agent already required to perform on the contracts. A bond is executed by an offeror or supplier identified in the instrument as the principal, together with the second party identified as the surety. The surety is an individual or corporation legally liable for another's debt. Look at your utility payments or your utility bills, your water bills, your phone bills. Find out who the first billing party is. Call up the company and ask them who the first billing party is on this account and give them the account number. You want to know who the first billing party is. You're a second billing party. You're a subcontractor, and you're legally liable. You took on a legal liability for another's debt. The default or failure to satisfy a contractual obligation. Clause 7.2, additional bond security must be included in all contracts for which a bond is required. So if a bond is required for the contract, you have to fulfill that bond, and then you have to have an additional bond security must be included in all contracts. So you have to, what's that? A bond security? That's a security instrument. All security instruments are bonded. 18 U.S.C. 8. Obligations and other securities of the United States includes all bonds. When you signed that document, I don't care what kind of document it was, with a wet ink signature, you bonded yourself. A man is bound by his words, and you use the words in their document, their grammar. Learn how to correct it. Go ahead, sister.
Keith, I heard what you said about getting a hold of these people, calling them and getting information, but they've been training the agents on the other sides of phones and so forth with limited information. So a lot of times when you're inquiring about a specific thing, they don't know. They might move you up to a second or third level man or woman to assist, but then again, the information is limited. So, and a lot of times they tell you their headquarter is like in the Philippines or it's in Zimbabwe or somewhere. So how does one truly get the information that you're suggesting to someone inquire about?
You look
How
up their
best?
SEC, you look up their SEC agreement. EX EX I think it's the EX 4.1 or 4.2 document on the SEC site. You get their name, you look up their name, SEC filing for EX 4.1, and it should be a trust indenture document. It's going to tell you who the trustee is. That's the one you want to talk to.
Question, is
We'll
that
go.
not also in the 10K filing? Or is that something completely else?
They may have a trustee on there, but you want the specific one with the address on the 4.1 document.
Okay, thank you.
It says 73.1.3 fidelity bonds. A fidelity bond is used to assure. Remember, that's grant. Grant means assure. Guarantee. Okay. Assure the faithful performance. So it's a performance guarantee of an employee's duties to his or her employer and the employer's clients, the third party. Benefactor, you're a client. The bond is used to cover losses such as employee thefts or embezzlements. A fidelity bond in an amount sufficient to protect the interest of the Postal Service may be required for any contract that requires supplier employees to handle Postal Service funds. So again, that's evidence that the City of Waterloo, having a fidelity bond rather than a surety bond, has a contract to handle Postal Service funds. When a fidelity bond is required, provision 7.3 fidelity bond requirements must be included in the RFP, and the amount must be reviewed periodically to ensure that the Postal Service interest is adequately protected. So let's look at 7.3 or 7-3. An offerer awarded a contract as a result of this solicitation will be required to submit a fidelity bond in the penal amount. See, they're telling us. Set forth in the schedule in a form acceptable to and within the time specified by the contracting officer. Corporate sureties must appear on the list in Treasury Circular 570. corporate sureties must appear on the list in Treasury Circle 570. And the amount of the bond may not exceed the underwriting limit stated for the surety on that list. Failure to submit an acceptable bond may be cause for termination of the contract for default. Interesting. Oops, I forgot to show it. So there's the 7.3 fidelity bond requirements. As of March 2006, the implementation of the Electronic Records Act. Oops. Okay. Well, we lost Sister Iman. But anyway, just so we didn't fall out of line there, I wanted to make sure we pulled that up to show you. Fidelity bond is specific when it comes to the performance and the indemnifying of the Postal Service, because they are the ones that are the already registered agent. So what do you guys got on the way out, guys? I gotta go get me something to eat.
I'm gonna try to find some documentaries and shit.
Well, I'm gonna, if you go back and see some of my videos on indemnification on Sunday nights, you're gonna get a lot of good information out of my Sunday night videos.
Right. Yeah. I'm trying to branch out of psychology shit like that. Get in more to the law stuff.
All right. Yeah, this would be a perfect place because everything starts with a bond, and that's what I've been talking about. A man is bound by his word. So what is the letter of the law as they're written in these statutes? Those are contract terms and conditions. If you want to be in indentured servitude, understand your indentured servitude is to the state, and it's implied at the local municipal level by those documents you sign without knowing it.
Why do these cocksuckers keep us so disadvantaged, though? Why, like, with the trust and the law? Why is it so disadvantaged?
Woe ye lawyers, ye have taken away the key of knowledge. They know it's important. If they don't have knowledgeable people, they'll be able to take advantage of them.
And who's they? Who would you say they? Is this like the Rothschilds, like the rulers? Like who's doing this? Who's scheming on us like this?
Well, you've got a lot of people that are in Congress that, well, let's just say it's all insider trading, the way I see it.
It's all the Jews, ain't it?
It's mutual funding.
It's all the Jews.
It's not any particular one. It's the people that are greedy and they know certain information and they kind of gather in certain circles, and those would be political circles where they know they've got a bunch of dumb people they can glamorize with these nice signs and their history of doing such great job at making all this money and being materialistic people in this popularity contest. That's all in the bells and whistles of a casino. It's a big gambling game.
Yeah. It's probably
what about you? Actually, like I was saying, Congress, we're going to be going over that too. Congress, it's insider trading, mutual funding, index funds. Like I mentioned earlier in the stream, it's all about the funding and who's funding it. We are. We're the ones that are financing it, as we recognize that term. If you're financing something, you're the one funding it. Well, finance, we find out, is settling. So we just have to learn how to settle ourselves in the truth and know that what is done is what ought to be done. There is nothing new under the sun. It's already done. It's as set. Problem is, wrong one's holding the title. Needs to be transferred. Matched up with the trust. Indemnified. Here's the receipt from the commanding officer that's going to serve me, the spoliated owner, indemnification through salvation. here, I'm going to surrender it to the proper party. It's a United States vessel now surrendered to the United States to settle and clear all accounts. The remainder is going to be a transfer of credits, a direct deposit into this account. Special directive that credits are to be given to the customer's account. I'm the one that's making the third-party payment as a customer, customizing the agreement. Go ahead, Iman.
Question that I have, Brother Keith, is that someone told me just recently, I don't know how true it is, but I know Trump has been doing a lot of things and he's been putting a lot of stuff where would you would say he's being very transparent with a lot of things that's that's going on with him. But what I was told is that the Kennedy family, there's one or two members of the Kennedy family that are laying low, but they're working behind the scenes to make a lot of changes. And from a lot of the history that I've learned about the Kennedy family was when there was something that happened, I think between 62 and 65 before, and correct me if I'm wrong, with their through assassination, when they found out where a lot of this corruptions were coming forth, they were trying to make make everything more transparent. And I really feel with the movement, the civil rights movement with them and Martin Luther King and Malcolm X, I think this is where they assassinated these people because they knew the corruption that was going on, and because they wanted change for all people, they had to remove them in order to bring about the change that we are in now. And I just feel that within my soul. I don't know. Correct me if I'm wrong.
Yeah, I really don't know. I can even tell you all kinds of things about the debt clock and this and that, but it's just a matter of using as much information as you can to discern how it applies to yourself. And if it really doesn't apply, then don't worry about it. You know, that's why it's important to learn the most we can about the one thing we do know that does apply, and that's that signature. Everything we apply it to, it has an effect. And we can strengthen that effect for ourselves by knowing what we're doing, instead of weakening ourselves by not knowing what it does and not giving a rat's ass.
Well, like I said, through the mind control and the different electronic devices, I think when a person, like when you, because myself and other people who are becoming aware of what's truly going on, you can find that family members with them are distant and confrontational in some ways. Even some friends people have lost. But it begins where when you show someone or they ask you a question and you're giving them the truth, like you said, you have to be the benefactor to the beneficiary in how to endorse something. Because of this mind control and conditioning, people are regressive. So is it natural that they're regressive, or are they being programmed to think that way when they become close to people in proximity? Because again, they said 6 feet, meaning if they're using these devices for mind control and keeping certain people at bay, that's what I believe we're in the time right now. And it's hard pulling people away from their comforts. That's all I can say. I yield. That's it.
Yeah, and that's why I think the best way is education. Simple education. And I'm not going to force it. I'm going to sit here, I'm going to keep doing this. And those people that want it are going to come seek it. I'm not going to throw pearl before swine. I'm not going to get all caught up in the rigmarole and drama of people not listening. You want to come listen, come listen. Again, it goes to the principle: don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. This is the most basic fault that we have, is not listening and hearing. The eyes to see and ears to hear. Start learning how to do that, and that's your best discernment. And with that, we are going to head out. You guys know me. I love you, but I don't give a rat's ass whether you love me back. I'm going to say I don't care if you hate me. I don't care if you don't like me. I don't care if you don't if you don't respect me. I don't care about none of that. All of that is on you. So may God bless you and have a good night. We'll see you again next time. Bye now.